state has the sole power and obligation to investigate, charge, and punish, so it also carries the responsibility to ensure that punishment does not go beyond what is justified. Why am I saying this? You don't need to be a law student like me to know that prosecution lawyers are state lawyers, because they're the one who controls the preliminary investigation. They have the executive powers to work with police department and Secretary of Justice to determine probable cause. Just go check all of their responses to this. They said that they don't fully control this investigation. Maybe my law professors are stupid and actually taught us wrong, but if that's not the case, you can see that in order for the state to push a charge, it needs to be verified by the prosecution, because police department does not have the enough legal knowledge to say that this is important, this specific evidence is important, is culpatory, mitigatory, all of that stuff, all of which are being decided by the state prosecutors themselves. That's why state gave them the power to administer executive exchanges with police department, something that a private defendant cannot have. Why is this important? Here's the problem with relying on private counsel in their hand. Very often, they don't have enough time. They don't have enough manpower. They don't have enough resources to gather evidence at the same scale at the state. Not all private counsels are rich. Most of the time, sometimes they cater to the middle class, which often simply points out that they don't have large teams of private investigators to expand all of their capacity. And on top of that, many private lawyers are only invested in these cases as the client's ability to pay. So in poorly funded or pro bono cases, the quality of defense can often significantly drop. That's why in your side, maybe you do have enough private counsel who represent black people in, maybe racial profiling by the police department that you rely the very investigation from. Therefore, it's going to be harder for them to investigate because one, they don't have enough incentive. Secondly, they don't do this poorly well. And thirdly, they don't have enough resources to do this. So the impact is that poor defendants become much more vulnerable to wrongful conviction or excessive punishment. Not because the case against them is necessarily stronger, but their side lacks the capacity to uncover what the state already knows. In other words, removing Brady makes justice depend more on wealth because rich defendants still build strong defense while poor defendants are left to expose to the full weight of undisclosed evidences. This multitude of harms of minorities actually happens within the status quo. The reason why Brady case happened has been the reason why Brady has been a precedent because supposedly Brady was supposed to be charged with death penalty, even though it's just supposedly a reclusion perpetua. So without the help or intervention of the prosecutor on that instances, then you actually created a wrongful conviction that is much more harmful because it equates to the life punishment. So Brady Rule ensures that prosecutors do not become mere instruments of a system that overburdens defendants and piles on charges while ignoring evidence that points out the other way. Once the prosecution already knows that we have exculpatory or mitigatory evidences that exist, withholding it means that you are actively helping produce excessive charges or excessive punishment. This is the duty of the state that you fail. Heck, this is even the reason why we offer plea deals, law against double jeopardy in the first place. And I want to note, this is an important framing. The essence of justice is not just a speedy trial. It's that state must punish only to the extent that truth and fairness must allow. That's why we have very extraneous process in litigating criminal cases because it is on the multitude of taking away someone's life. So Brady disclosure therefore matters because justice is not just about convicting the guilty in a fast manner, but also ensuring that no person is treated more harshly than the facts actually justify. So Brady is what forces prosecutors to act as a minister of justice rather than puppets of conviction. So these proceedings are not a game in which prosecutors may treat disclosure as a matter of strategy. That's why in the status quo, human liberty, punishment, and all of these instances are important because you put an entire person's future at stake. So the state cannot be allowed to conceal evidence simply to gain advantage. It is also the reason why in debates, to gain proper discussion, you need to be quote-unquote charitable to get the real crux of the issues. Yes, it is an adversarial system, but it's still a justice system where justice is literally the priority. So this already takes out their main case. But then they said this prolongs the process of the judiciary. That argument simply misses why criminal procedure is designed to be demanding in the first place. Like in criminal cases, we do not not convict on mere reasonable suspicion. We have different standard. We require proof beyond the reasonable doubt, precisely because the consequences are so severe. These are the cases prosecutors handle where what is at stake is a person's liberty, years of life, or maybe sometimes it literally equates to their life if you do have death penalty. So if Brady compliance slows the process, that is not a flaw in the system, but a necessary cause of making sure that the state does not punish people on an incomplete or distorted facts, which is a necessary trade-off in our side. When the stakes are this high, speed can never be valued more than accuracy and fairness. But again, God check this. Retrials usually do not revolve around brand new evidence being introduced from nowhere. The real issue is that suppressed evidence should be disclosed in the first place in the initial trial. So in other words, the harm already happens at the initial trial because that's where the defendant was forced to answer the case without access to full truth. The reason why we have retrials in the first place is to argue about the legality of all of the cases that was charged. It's not about the evidence. That's why it's literally not placed in the retrials in the first place. Lack of matter. But sure, I'll take a POI before I go. 3, 2, 1. Okay, it seems like we're winning. But then they said that, this just happens because they want to avoid trial. No, literally, there's already a case. You present these evidences in trials because if they want to avoid trial, therefore they're not going to charge these preliminary investigations in the first place. There's no case versus the defendant if it happens because they want to avoid trial. So literally, that's outside of reality. And their second response to this is that it's bad because it should be handled by the police. Take note. The reason why this was placed in the first place is because a lot of police departments are also mischarging a lot of individuals, and it was handled by the prosecutors. Most of the time, they're being racially profiled, like those black individuals back then in the US, and it also happens right now. So literally, police as an arbiter on this, and the main function on this isn't really that reliable. That's why you need someone from the state that has enough legal knowledge to know what is precisely the reason why we have these charges in the first place. Also in the first place, the reason why prosecutor has to intervene in this procedure is that one, judges do not control and are not visible in this investigation. They're just arbiter of the law. Two, because especially it's dangerous if you allow just police officer to often engage in racial profiling because they are not adequately equipped with legal judgment needed to assess what evidence must be disclosed or how that evidence affects the guilt and punishment that we have. Very proud to oppose.